The Chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Director, did you make the decision not to recommend criminal charges relating to classified information before or after Hillary Clinton was interviewed by the FBI on July the 2nd?
After.
Okay, then I'm going to need your help in trying to understand how that's possible. I think there's a lot of prosecutors or former prosecutors that are shaking our heads in how that could be the case, because if there was ever any real possibility that Hillary Clinton might be charged for something that she admitted to on July the 2nd, why would two of the central witnesses in a potential prosecution against her be allowed to sit in the same room to hear the testimony? Now, I've heard your earlier answers today. You said that, well, it was because the interview was voluntary and they were her lawyers. But I think you're skirting the real issue there, Director. First of all, the fact that it was voluntary, it didn't have to be, right? You could have impaneled an investigative grand jury. She could have been subpoenaed. And I know you've said that you can't comment on that, and I don't really care about the decision about whether or not there should have been a grand jury here. But since you didn't have one, it goes to the issue at hand about whether or not this interview should have ever taken place. With due respect to the answers that you've given, the FBI and the Department of Justice absolutely control whether or not an interview is going to take place with other witnesses in the room, because the simple truth is, if under the circumstances as you've described, those interviews never take place. If there was ever any possibility that something Hillary Clinton might have said on July 2nd could have possibly resulted in criminal charges that might possibly resulted in a trial against her relating to this classified information, well, then, to use your words, Director, I don't think that there's any reasonable prosecutor out there who would have allowed two immunized witnesses central to the prosecution to proving the case against her to sit in the room with the interview, the FBI interview of the subject of that investigation. And if I heard you earlier today, in your long career, I heard you say that you've never had that circumstance. Did I hear you correctly?
That's correct. But
okay, and I never have either, and I've never met a prosecutor that's ever had that. So, to me, the only way that an interview takes place with the two central witnesses and the subject of the investigation is if the decision has already been made that all three people in that room are not going to be charged.
Okay, can I respond?
Yes, please.
I know in our political life sometimes people casually accuse each other of being dishonest, but if colleagues of ours believe I am lying about when I made this decision, please urge them to contact me privately so we can have a conversation about this. All I can do is tell you again, the decision was made after that because I didn't know what was going to happen in that interview. She maybe lied during the interview in a way we could prove. Let me finish. I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I've met. And I know you've defended the people that were involved in this as being great, but if it's never happened, I wonder why this is a case of first precedent with respect to that practice that you and I have never seen in our careers.
You and I don't control the universe of what's happened. I suspect it's very unusual. A key fact, though, that maybe is leading to some confusion here is we had already concluded we didn't have a prosecutable case against Heather Samuelson or Cheryl Mills at that point. If they were targets of our investigation, maybe we would have canceled the interview. But frankly, our focus was on the subject. The subject at that point was Hillary Clinton.
All right, let me move on. According to the FBI's own documents, Paul Gambetta was, in his first interview on February the 18th, told FBI agents that he had no knowledge about the preservation order for the Clinton emails, correct?
I don't know the dates of that, but I'm sure it's in the 302.
Okay, but then 2.5 months later, on May the 3rd, his second interview, he made a 180-degree turn. And he admitted that, in fact, he was aware of the preservation order, and he was aware of the fact that that meant that he shouldn't disturb the Clinton emails, correct?
Yep.
Okay, well then I need your help again here, because when I was at the Department of Justice, your reward for lying to federal agents was an 18 U.S.C. 1001 charge or potential obstruction of justice charge. It wasn't immunity.
Depends on where you're trying to go with the investigation. It's a low-level guy and you're trying to move up in the chain, you might think about it differently.
Well, he lied to an FBI agent. You don't think that's important?
Oh, it's very important. Happens all the time. Unfortunately, it's very, very important. Sometimes you prosecute that person and end their cooperation. Sometimes you try and sign them up.
But if they lie to an FBI agent after they're given immunity, they violated the terms of their immunity agreement.
Oh, sure, after the agreement.
And so that's my point. He shouldn't have immunity anymore.
No, I'm sorry, I may have misunderstood you. He lied to us before he came clean under the immunity agreement and admitted that he had deleted the emails.
No, not according to the FBI's documents. He had the immunity agreement in December of 2015. These interviews took place in February and March and May of this year, 2016.
Combetta?
Combetta.
Okay, then I'm confused and misremembering, but I don't think that's right.
Okay, well, my time's expired, but I have one last question, and I think that's important. At this point, based on everything, do you think that any laws were broken by Hillary Clinton or her lawyers?
Do I think that any laws were broken?
Yeah.
I don't think there's evidence to establish that.
Okay. Well, I think you're making my point when you say there's no evidence to establish that. Maybe not in the way she handled classified information, but with respect to obstruction of justice. And you've got a pen here. I just want to make sure the record's clear about the evidence that you didn't have, that you can't use to prove. So this comes from the FBI's own report. It says that the FBI didn't have the Clintons' personal Apple server used for Hillary Clinton work emails. That was never located, so the FBI could never examine it. An Apple MacBook laptop and thumb drive that contained Hillary Clinton's email archives was lost, so the FBI never examined that. 2 BlackBerry devices, provided the FBI didn't have SIM cards or SD data cards. 13 Hillary Clinton personal mobile devices were lost, discarded, or destroyed with a hammer, so the FBI clearly didn't examine those. Various server backups were deleted over time, so the FBI didn't examine that. After the State Department and my colleague, Mr. Gowdy, here notified Ms. Clinton that her records would be sought by the Benghazi Committee, copies of her emails on the laptops of both of her lawyers, Cheryl Mills and Harold Mills, and Heather Samuelson, were wiped clean with bleach bits, so the FBI didn't review that. After those emails were subpoenaed, Hillary Clinton's email archive was also permanently deleted from the Platte River Network with bleach bit, so the FBI didn't review that. And also after the subpoena, backups of the Platte River server were manually deleted. Now, Director, hopefully that list is substantially accurate because it comes from your own documents. My question to you is this. Any one of those in that very, very long list, to me, says obstruction of justice. Collectively, they scream obstruction of justice. And to ignore them, I think, really allows not just reasonable prosecutors, but reasonable people to believe that maybe the decision on this was made a long time ago not to prosecute Hillary Clinton. And with that, I yield back.
Director, do you care to respond?
It's very briefly, to ignore that which we don't have, we're in a fact-based world. So we make evaluations based on the evidence we're able to gather using the tools that we have. So it's hard for me to react to these things that you don't have. So that's my reaction to it.
The chair recognizes the gentleman from Georgia, Mr. Collins, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, I appreciate you being here. You are, I believe, forthright, much more so than you said is in any criminal case we've had. But I'm also still in the military. I'm still in the Air Force Reserve. I went to my drill back in July. I was hit by an amazing amount of questions from different service members on this issue of how does the former Secretary of State get to do this, and yet we have members of the military who are prosecuted all the time. Your statements earlier were fairly startling when you said, I don't know of anybody else that's been classified as this. Just since 2009, the Department of Justice has prosecuted at least 7 people under the Espionage Act, all for very similar cases. Now, you said go look at the facts. Well, we're looking at the facts in these cases. The interesting one, and you know, you said that in looking back at your investigation, mishandling or removal of classified information, we cannot find a case that would support bringing criminal charges on these facts. All right. Well, it didn't take nothing but a simple legal search to find a Marine that fallen. Now, I guess their name is not Jane or Joe, so they did get prosecuted. Okay, and this is the issue under 18 U.S.C. 793F, gross negligence. This is what the Marine did. They took classified information that was put into a gym bag, cleaned out, washed, and took. All right, simple mishandling. Court of Appeals actually upheld this case, and this is what they said, that the purpose of federal espionage statutes is to protect classified documents from unauthorized procedures, such as removal from proper place of custody, which would mean how you deal with this, Regardless of means of removal, it was apparent gross negligence and was approximate cause of the document's removal. It is, and they quoted United States v. McGinnis, said, it is clear the Congress's intent to create a hierarchy of offenses against national security ranging from classic spying to merely losing classified materials through gross negligence or the mishandling of. It was sort of also ironic for me that when I had to go back in July in this past month when I went back, I had to do my annual information assurance training that went through everything that we have to do with handling classified information. I have been in a war zone. I've been in this is just common knowledge among most everybody in the world, obviously not to the Secretary. How can you then explain to me this Marine's mistake in taking classified documents or mishandling them is more severe than the Secretary of State who sent and received classified emails on a regular basis, including those that were originally classified, not those that were classified later, but were originally classified?
Yeah, first of all, I'm familiar with the case, and I'm quite certain it's not a 793F case. It was prosecuted
His
as
conviction was under 793F.
Yeah, I don't think, I mean, I'll go back and check again. I'd urge you to, too. I'm pretty sure it's not under the gross negligence prong of 793F. But it's a Uniform Court of Military Justice prosecution, not by the Department of Justice, am I remembering correctly?
This was from and is appealed out in the U.S. the Court of Appeals for the Armed Forces did actually hold it on this. Yes.
But regardless, I think even, I don't think this is under the same provision, but even there, that's a case involving someone who actually stole classified information, hard copies. What people need to remember, and I don't say this to make a little of it, I think it's a very serious matter. What happened here is the Secretary used an unclassified email system, her personal system, to conduct her business.
And let's just stop right there. That in and of itself, and I understand this, Dr. Comey, we've been through, you've been through a lot of questions, I apologize. But let's just come back to the basics here. We're trying to parse that I didn't have such a Sandy Berger or all these others who've been prosecuted, they took a hard copy. In today's society, and even understanding if you go through any information assurance class, anything else, they tell you it cannot be on a personal laptop. In fact, there was another chief petty officer who had classified information on a personal computer. It went back and forth at war zone. That is not physical documents. It's on a, to parse words like that is why the American people are fed up. They're fed up with the IRS commissioner when he does it. They're fed up here. I'm not attacking your, I think you're one of the more upright people I've met. I think you just blew it. I think the Attorney General blew it. I shared this with her. And I think when we come to this thing, there's no other way that you can say that there's no others that resemble this. As a lawyer, you're taught all the time to take facts and put them, they may not be exact, but they fit under the law. You can't, I mean, so I guess maybe I'm going to change the question because we're going to go down to a dead end. You're going to say it wasn't. But let me ask you this. I want to change questions. Do you honestly believe that a lady, a woman of vast intelligence, who is the First Lady of the United States, who is a senator who had access to classified information, all the members here do, who was Secretary of State who had even further classification ability, even beyond what we have here. Do you believe that in this case, honestly, she was not grossly negligent or criminal in her acts?
First of all, I don't believe anyone other than my wife. My question is, what evidence do I have to establish that state of mind? And I don't believe I have evidence to establish it beyond a reasonable doubt.
Then really what we're saying here is this. She is, and this is in essence what you're saying. You said, I can't prove it, and I understand. There's a lot of folks out there in the law that, they come to us all the time. I'm an attorney as well, and they come to and say, it's not what we know, it's not what we think, it's what we can prove. I get it. But here's the problem with this, and this is the person who's asking to lead this country. If she can hide behind this and gleefully get approval from the FBI through an investigation, which has been covered here thoroughly, then I just do not understand. She is either the most arrogant, which probably so, or the most insanely naive person we've ever met. Because when I actually show evidences of basically the same thing, which you can take facts and correlate to law, this is why the armed forces right now have the new term called the Clinton defense. I didn't know. I didn't mean to. It's on my, it's the Clinton defense. With questions like this, Director, we have give the ability now to where nobody takes this seriously. And this is why people are upset. When it was originally classified, she can tell all the stories she wants. She can have the backup from you that no prosecutor, which is, again, amazing to me, that a law enforcement would tell the prosecutor, because how many times I've been on both sides of this, where the law enforcement agent said, I'm not sure we have a case here, but when the prosecutor looks at it, the prosecutor says, yeah, there's a case here. I don't really, frankly, no offense, care what, if I'm prosecuting, what the law enforcement officer, if I can see the case and I can make it, that's my job, not yours. And yet now we have a whole system that has been turned upside down, not because I don't believe your honesty of your people, but I believe you blew it because you, frankly, didn't have the whole situation into effect where the FBI would look political. And unfortunately, that's all you've become in this. And it's a sad thing because y'all do great work. You have do great work, and you will do great work. But I think it's time to start, we just bring down the curtain. There's a wizard behind the thing, it's Hillary Clinton, who is playing all of us because she's not that naive. She's not stupid. She knew what she was doing because she was simply too bored. If she, God forbid, gets into 1600 Pennsylvania Avenue and just gets bored with the process, then God help us all. Mr. Chairman, I yield back.
Mr. Chairman, there's only two.
The Director is permitted to respond.
Yeah.
Two pieces of that I need to respond to. First, you said hiding behind something. This case was investigated by a group of professionals. So if I blew it, they blew it too. Career FBI agents, the very best we have were put on this case, and career analysts. We are a team. No one hid behind anything. American citizens should insist that we bring criminal charges if we're able to investigate and produce evidence beyond reasonable doubt to charge somebody. That should be true whether you're investigating me or you or Joe Smith on the street. That's the way this case was done. It's about evidence. And the rest of it I'll let go.
Mr. Chairman, I will, and I apologize if you're not saying, just to comment. I'm not, this is the problem, though. When you take it as a whole, it's been said up here, this is a unique case. You've talked about it being a unique case. Director, this is a unique case because I truly, and I don't think you convinced hardly anybody except your own group, I don't think you ever said they couldn't blow it. They blew it. Anybody else would have been prosecuted under this. In my humble opinion,
You're just wrong.
you say
You're
no.
just wrong. We'll just have to agree to disagree.
Well, unfortunately, there's a lot to disagree on this. Thank you, Mr. Chairman.
Time of the gentleman has expired. The gentleman from Idaho, Mr. Labrador, is recognized for 5 minutes.
Thank you, Mr. Chairman. Director Comey, I've always appreciated your testimony before this committee, and I respect the work that you do for the FBI. When you made your recommendations to the Department of Justice to not prosecute Hillary Clinton, I actually disagreed with your decision, but I appreciated your candor in explaining to the American people and to us those recommendations. Since that decision, I continue to view you as honorable and a strong leader for the critical federal agency. In fact, I did 20 town hall meetings over the recess, and I was lambasted at every one of them. In fact, I think I lost votes because I defended your integrity at every one of those town hall meetings. And I told them why, even though I disagreed with your conclusions, I thought you came to it from an honorable place. However, as more information has come to light, I question the thoroughness, and I'm not questioning your integrity, but the thoroughness and the scope of the FBI's investigation. In the past week, we have learned of the grants of immunity to several key witnesses in the Clinton investigation, including Hillary Clinton's former chief of staff and one of the individuals responsible for setting up her server. I'm really disappointed by this revelation and confused as to why these immunity grants were necessary and appropriate given the circumstances. It appears to me that the FBI was very early in this investigation too willing to strike deals and ensure that top officials could never be prosecuted for their role in what we now know was a massive breach of national security protocol. We have a duty to ensure that our FBI is still in the business of investigating criminal activity. So at what point in the investigation was Cheryl Mills offered immunity?
Cheryl Mills was never offered immunity, not to quibble, but she was given letter immunity to govern.
At what point?
June of 2016, so June of this year, so about 11 months into the investigation.
So to be clear, was she offered immunity for interview and potential testimony or for turning over the laptop as evidence?
But turning over the laptop as evidence, it governed what could be done in terms of using it against her, that laptop.
To your knowledge, was Cheryl Mills an uncooperative witness prior to the immunity deal?
I think our assessment was she was cooperative. I forget the month she was interviewed, but she was interviewed fully before that.
And she always cooperated?
I think our assessment was, again, this is the odd way I look at the world, we had no reason to believe she was being uncooperative.
So could this investigation have been completed without these grants of immunity in place?
In my view, it couldn't be concluded professionally without doing our best to figure out what was on those laptops. So getting the laptops was very important to me and to the investigative team.
So in your vast experience as an investigator, as a DOJ attorney, now as an FBI director, how many times have you allowed a person who is a material witness to a crime you're investigating to act as the lawyer in that same investigation?
Well, to let is what I'm stumbling on. The FBI has no power to stop someone in a voluntary interview.
You're speaking, let's just be honest. You allowed, the FBI allowed Cheryl Mills to act as the attorney in a case that she was a material witness. How many times have you done that?
In the same sense that I'm allowing you to question me.
How many times have you done that?
I can't stop you from questioning me.
How many times have you done that prior?
I have not had an experience where the subject of the interview was represented by a lawyer who was also a witness in the investigation.
Okay, so you have never had that experience.
Not in my experience.
You prosecuted terrorists and mobsters, right?
Correct.
And during your time in justice, how many times did you allow a lawyer who was a material witness to the case that you were prosecuting to also act as the subject of, as the attorney to the subject of that investigation?
Yeah, as I said, I don't think I've encountered this situation where a witness, a lawyer for the subject of the investigation was also a witness to the investigation.
So this was highly unusual to have?
In my experience, yes.
Okay. In your answer to Chairman Chaffetz, you indicated that you had no reason to disbelieve Paul Gambetta when he told you that he erased a hard drive on his own. Is that correct?
Correct.
However, in the exchange on Reddit, he said, I need to strip out a VIP's email address from a bunch of archived email. Basically, they don't want the VIP's email address exposed to anyone. Those two statements are not consistent. How can you say that he was truthful when he told you nobody told him to act this way, but yet you saw this Reddit account that says where they told him that he needed to act in this way?
I think the assessment of the investigative team is those are about two different subjects. One is a year before, in the summer of 2014, about how to produce emails and whether there's a way to remove or mask the actual email address, the HRC, whatever it is, .com. And the other is about actually deleting the content of those emails sitting on the server.
It seems like in your investigation, you found time after time evidence of destruction, evidence of breaking iPhones and other phones, all these different things, but yet you find that there's no evidence of intent. And I'm a little bit confused as to your interpretation of 18 U.S.C. 793F. On the one hand, you've said that Secretary Clinton couldn't be charged because her conduct was extremely careless, but not grossly negligent, correct?
That's not exactly what I said.
That's what you said today. But you've also said there was no evidence of her intent to harm the United States. So, but you'll agree that a person can act with gross negligence or even act knowingly without possessing some additional specific intent. So which is it? Is it a lack of gross negligence that she had or a lack of intent?
In terms of my overall judgment about whether the case was worthy of prosecution, it's the lack of evidence to meet what I understand to be the elements of the crime, one, and two, a consideration of what would be fair with respect to how other people have been treated. Those two things together tell me, and nothing has happened that's changed my view on this, that no reasonable prosecutor would bring such a case. The specific intent question, yes, I agree that specific intent to harm the United States is a different thing than a gross negligence or willfulness.
So just one last question. You talked about Mary and Joe. And Mary and Joe would be disciplined at the FBI if they did what Hillary Clinton did. If Mary and Joe came to you and asked for a promotion immediately after being disciplined, would you give them that promotion?
Tough to answer that hypothetical. It would depend upon the nature of the conduct and what discipline had been imposed.
And what if they ever asked for a promotion that would give them management and control of cybersecurity of your agency and the secrets of your agency after they had done these things? Would you give them that promotion?
That's a question I don't want to answer.
All right.
The time of the gentleman has expired.